bring the funds that are for personal services that are currently in the provincial equitable shares into the national domain through the voted funds of the national department to this NHI fund, and then for the fund to be the purchaser rather than the provincial administrations. And that changes the functions of the provincial departments. And those functions are outlined in the schedule, in Schedule 1, where there are amendments to the National Health Act. And those amendments make the provincial departments responsible for the stewardship of the entire health system, not just the public health service, the entire health system in their province. And they are responsible for making sure that all providers and everything that happens in the service of the people in that province are catered for and paid for in an appropriate manner. But it's also the responsibility of the provinces to be the provider of the public service, but not the purchaser anymore. So that is what the intention of Clause 32.2 is. And the mechanism by which it is elaborated here is to move the functions in the Health Act as they have been moved before, but to move them into the national domain, and then for the minister to delegate the provision functions back to the provinces, and then they get paid for those services from the fund. So that is what is provided for in Section 32.2, and it must be read in conjunction with the amendments that we've discussed before in the Portfolio Committee in the schedule. So we in the National Department are comfortable that, notwithstanding all the comments that have been made, and we know that this is not something that happens in a short space of time, it happens over financial years and through the budgeting process, but the provision is important to achieve the objective. So we are not recommending changes. So Clause 33 deals with the other half of our dichotomous system, and that is the role of the medical schemes. There were a lot of inputs from not only medical schemes, but others, and there was discussion in the oral hearings as well as in the Portfolio Committee about this clause. And part of the concerns that were raised is about the words fully implemented. So the question was, why does the minister have the jurisdiction, and under what basis would the minister decide that the NHI has been fully implemented? De facto, what will happen and what's provided for in the regulations, and it's very clear in the transitional provisions, stated several places in the transitional provisions, is that there will be an incremental and stepwise graded implementation. So things do not all happen when there's a switch on of the national health insurance. And in fact, when we get to the last clause, we will all note that the commencement dates may be different for different clauses. So the intention is that there comes a point at which, when the benefits are crystal clear and the minister has published those benefits, that there must not be a duplication and a second way of paying for those same sets of benefits. So we feel that it is best to leave this clause as it is. I've already mentioned the potential conflict with clause Section 8.2b, which we have recommended be removed so that it's not in conflict with Section 33. Clause 34 deals with the National Health Information System. So Section 74 of the National Health Act already provides for a National Health Information System. And what this clause seeks to do is to ensure that there's no conflict between the system and the reporting in the national sphere, which will be under the National Department of Health, as it is at the moment under Section 74 of the National Health Act, and those functions which the fund must have, and the information system which it must have at its disposal to administer the benefits. And that is to ensure that the public, the users in the public, get their benefits, and that the providers are paid for the benefits that they deliver to the public. So everybody in the system needs information to be able to do that, and it needs to be managed in a way that protects the privacy of the individual, but at the same time makes it possible for the healthcare provider to look after that individual and for the managers to manage strategic purchasing and ensure that we use the data to get best the volumes, to get best prices, etc., etc. So it's the interoperability of the systems that matter. We have published already from the National Department the interoperability framework. It's done in conjunction with the private sector and all the provinces. And so what this is providing for is to make sure that there's no conflict in the way in which these digital systems provide the information for all of us. So we do not propose any amendments to that clause 34. Now, clause 35 provides for the fund to purchase. Now, I've just explained clauses 32 and 33, which affect the public sector and the private sector. Now, if the fund is going to be the purchaser, replacing the provinces in the public sector as the purchaser and replacing the medical schemes for the bulk of the services and benefits in the private sector, the question is how it purchases. And this clause explains how the framework, the outline, and enables the fund to purchase through a number of different mechanisms. One, by transfer payments, in other words, lump sum payments. Secondly, for global budgets based on diagnostic-related groups, which is a particular approach that is being used globally, but also being transferred through capitation arrangements in the primary care environment and other arrangements for the purchasing of the emergency medical services on capped case-based fees. So what this clause does is it provides an enabling environment, and the comments that have been made, I think, largely recognize, and those who work in the healthcare financing environment recognize that you need different kinds of payment mechanisms. But we do suggest two amendments to make sure that there's absolutely no ambiguity in this clause. The first one is in clause 35.2, where the impression is created that there'll just be a lump sum transfer payment, and that would do no different from how the provincial equitable shares, for instance, work at the moment. What is intended, and the wording that we are proposing is shown on the right-hand column, is that the fund must reimburse payments directly to the accredited and contracted central, provincial, national, specialized, and district hospitals based on a global budget or diagnostic-related group. So it's not just replacing one payer with another payer, it's also changing the mechanism by which the payments are made. So that is our recommendation on clause 35.2. And then in clause 35.3, again, it's this question of transfer. And that the comments that were made, we recognize that the way in which they were interpreted is problematic. So we recommend a change that says funds for primary healthcare services must be reimbursed directly to accredited and contracted primary care providers and establishments at the sub-district level as outlined in section 37. And section 37 we are coming to at the moment, it's the contracting units for primary healthcare and the way in which the districts are managed. And they are also elaborated on in the amendments in the schedule to the National Health Act. So we do have some proposed amendments there. Now, clause 36 introduces a different role of a district health management office. Once again, we don't envisage this to be an overnight amendment. There are district offices in the current structures in the provinces, but once the provincial functions change, the functions of the district offices also need to change. And the intention is that the provinces must, if you see the amendments in the Health Act in Schedule 1, will give a far more powerful stewardship responsibility to the provinces at that level, but make it a more direct responsibility at district level to integrate the health services with social welfare services and other functions that are delivered at the district level. So the roles of the district health officers are elaborated in the National Health Act in the amendment, which is section 31A of that amendment. And this clause merely directs one to the amendment in the National Health Act. And we do not recommend any changes to this clause in the bill. we feel differently about the contracting unit for primary healthcare, and we've listened to comments that were made during the visits into the provinces, in the portfolio committee, and others who have submitted comments, that in fact, what we are trying to achieve with the contracting unit for primary healthcare is that it should be part of the purchasing function. So it's to ensure that the services are indeed purchased. So the province and the district levels are involved in the provision and making sure that they are coordinated between the public and private providers at that level. But the contracting unit is the mechanism by which the fund ensures that people are paid for the services that they deliver and the benefits and the outcomes of those benefits. So we are proposing an amendment to clause 37.1, which should read, contracting units for primary healthcare must be established as part of the fund to plan the funding of accredited and contracting healthcare providers and establishments, and then the rest of it unchanged, such as prevention, promotive, curative, rehabilitative, ambulatory, home-based care, and community care in a demarcated geographical area. And that B be amended that it is not just the preferred organizational unit, it is the organizational unit through which the fund facilitates the development of the contracts to be entered into between the fund and the public and private healthcare providers and establishments for the provision of primary healthcare services within a specified geographical area. And the implications of this is that the amendments to clause 31B in the National Health Act will be deleted in its entirety and replaced by this amendment. Clause 38 deals with the Office of Health Products Procurement. There were quite a lot of concerns that this is centralizing procurement and how does it conflict with other procurements in government and so forth. And we're not convinced by that any of the comments that were made are in conflict with what is stated in the bill as it is at the moment. The intention is that one has enormous buying power once you have the kind of volumes that are anticipated with a central formulary or national formulary. The formulary comes out of the benefits committee, the benefits advisory committee, and the inputs that ultimately end up there from the various clinical guidelines and so forth. So once medicines, diagnostics, and other devices are determined to be part of the requirements for a benefit, they will then form part of the products that need to be procured en masse, and this is only at procurement level. So in other words, it's if you like, the national transversal tenders of the health system that would be in this domain, not the purchasing and the logistics of suppliers. That will be the job of the respective public and private providers, health establishments or individual providers, who will then be able to purchase the goods, the health products and other goods that are part of the health products procurement of the fund. So it's not that the fund is going to have a massive warehouse and procure and stockpile things or anything like that. It's merely setting up the national tender and the national pricing once it's determined that a particular item, let me call it an item, a health product in this parlance, is part of the benefits that are required. However, there were comments that it's practice in government that an office is an entity on its own, and so we might create confusion that we are intending to have a separate entity within an entity for this, and it's nomenclature rather than anything else. So we would like to propose that this be called the Health Products Procurement Unit and not elevated to an office status. It does make a difference in the way in which the public sector reads these things. But other than that, we do not recommend any changes to the remainder of this, this clause that deals with products procurement.
Chris,
Yeah.
just a reminder that we'll have tea time at 11 o'clock.
Thank you, Chair.
Chair,
Should I
point of
proceed? I
order,
saw a hand,
please.
Chair.
Sorry, I'm also on full screen view. Let me just,
Chair, I heard the Honourable Clerk asking
yes,
to speak.
Honorable Clerk.
Chair, sorry to interrupt the presentation, but I've just had a couple of messages to say that the YouTube coverage has ended on the committee. So I think that's quite critical for, our stakeholders to be involved in watching. If we could just look at that technical issue. Thank you, Chair.
Thank you. Let us see under participant. That's probably what happened earlier. YouTube streaming. Well, we can always take tea time now and sort this out over tea time. We're just 3 minutes away from tea time.
Agreed, Chair.
Honorable Muniai.
Hours raising to be noted when they finish.
Yes, it's your turn, Honorable Muniai. When the presentation is finished.
Yes.
Oh, okay. All right.
Thank
so,
you. Thank you, Doctor.
All right. We'll have tea time now, honorable members, so we can inquire about the YouTube streaming. And we will be back at 11:15. Thank you.
Thank you, Doctor. And Chairperson of the PC.
Thank you, Chair.
Thank you very much, Honourable Chair. So we are moving to clause 39, which deals with accreditation of service providers. This was also a clause that had a lot of comments and a lot of suggestions were made at various forums, including in the Portfolio Committee. And so we would like to just try and clarify what the intention is and how we understand this particular clause. So the intention and what is stated in the bill is that for a provider to be able to deliver the benefits to the users, they must do a number of things. So it starts in subsection 2 by saying that they must be in a possession of a certification by the Office of Standards Compliance and proof of registration of the professional councils. So for establishments, which is clinics, hospitals, GP practices, and so forth, they need an Office of Health Standards Compliance registration. And for individuals, the actual doctor, nurse, etc., we need to be sure that they are currently registered at that time with a professional council in order for them to be paid by the fund, which is the norm in the public service at the moment anyway. So the question is really, how do we envisage this certificate being issued and using what is provided here in the bill to ensure that we improve quality over time? And I want to emphasize the over time because it is very clear in the transitional provisions, as I've mentioned already, that this is about over time. It's not something that happens as a snapshot. So we recognize and we know in the department that there are many parts of the country where facilities at the moment are suboptimal. And so those establishments would not be able to get full marks for an assessment by the Office of Health Standards Compliance. And by the way, that applies to public and private facilities who would fail to get 100% for any adjudication at the moment. However, we know that this happens over time and there's a graded process. So what is happening at the moment, and if one is familiar with the reports from the Office of Health Standards Compliance, they issue 3 different levels of grading when they conduct inspections. Obviously, if a facility is dangerous, then something must be done to shut it down while it's being fixed. But if it is just suboptimal and we want to encourage the provider who's responsible for that facility and the services in that facility to improve either the physical buildings or the staffing or whatever it might be that is being adjudicated by the Office of Health Standards Compliance, then one wants to give them at least an entry into the market, if you like. One wants to acknowledge that the facility is there, it does provide benefits, but it's not up to standard. So that is what Office of Health Standards Compliance is doing. Now, it's not the intention of the fund to interfere with that independent process. It's very important that that happens outside of the fund. But it is obviously extremely important to the fund that we are not purchasing services where the quality is bad and where there's potentially a danger or some other really unacceptable behavior that goes on in servicing the patients that are getting benefits paid for by the fund. So that's why you've seen elsewhere in the bill the intention of the fund to work very closely with the Office of Health Standards Compliance. Now, we do that with other entities as well without impinging on their regulatory mandates, some of them in the health environment, some outside. For instance, with SAPRA, where neither the department nor the putative NHI fund would interfere with the autonomy of that entity. So our comments on everything we've heard related to this clause is that there is no intention and there is nothing that we read in this clause of the bill that will exclude suboptimal entities from being able to continue to provide services and be paid from the fund at the outset. What there is every intention to ensure that everybody who is accredited is, number one, up to standard and improving their standards over time. But more important, and what's been left out of the debate and barely commented on, is that they must have a required range of services. So if you are a very small clinic or a single practice GP, you will provide a smaller range of services than a big complicated hospital that has neurosurgery and heart surgery and so forth. But whatever services you provide in that range of personal care services The fund must ensure themselves that you have allocated the appropriate mix of health personnel. You must adhere to the standard treatment guidelines and prescribing within the formulary, and we'll talk about the formulary later. You must adhere to the referral pathways. You must have a link to the information system for continuity of care, your patients, in other words, that portable health record. You must adhere to the national drug pricing regimen, and only then may you enter into a contract with the fund. So there are a number of steps, and we will take time, and I think the honourable members are quite aware we are busy at the moment with determining what are the standard operating procedures and the putative or ultimate regulations, which will, once there's an act, we'll be able to table for consultation to make all of these things possible. So all of this is provided for in the regulations, which we will get to in a moment. So from the department side, we make only one recommendation to get us all less anxious about the fact that we might exclude, in particular, poorly resourced or poorly structured public health facilities. And so we are recommended in subclause 2 that where we refer to the possession of a certificate from OHSC, that we say a graded certificate. We know what that means because OHSC has published these graded certificates, and the entry-level grading is not at the end of the road for anybody. They are required, and we will require from the fund over time, the investment into those services to get better and better quality. But you have to start somewhere, and you need to allow people to come in on the first step while others are already on the final step of the adjudication. So, Honourable Chair and members, we would like to see just this one amendment, and we would like to try and do away with the anxiety that some parties have had, some of the professional bodies have had, and some of the communities have had in the various comments that we have heard. We are well aware of those issues. In section 39.5, we talk about and I mentioned it when I looked at section 35.2 as well. I mean 39. I think we're in 39. We deal with 39.5. Yes. We deal with the linkage to the registration system, and we refer specifically to the health patient registration system in the bill. That is because that is what the system is called at the moment, but it may not always be called the health patient registration system, because that is a proprietary label that we have given to the system at the moment. So the only other recommendation we make is that we specify that, and we remove the health patient registration system, and we reword it that it is through an information platform as prescribed and accredited by the fund. So at the moment, it is the HPRS, but it may change over time because that's what the nature of technology and what we are moving. So, Chair, I think that's the only recommendation that we are making in terms of accreditation. It's a very, very important function in facilitating change and facilitating improvement in services. And we think the way it's stated is going to achieve that. Now, earlier I spoke in one of the clauses above about the information systems of the country. And I mentioned that it would link to clause 40 as well as to section 74 of the National Health Act. And we have made sure that all the comments that have been made are harmonized between these three different pieces of clauses of legislation so that we're not in conflict. The intention is that the fund must have a platform that is secure, can't be hacked, protects the public's information, the private information, and allows for the interoperability of all the systems and the portability of individual records so that the patient doesn't have to worry about whether their history is going to be lost, or whether when they move from one part of the system, either on referral or if they transfer their lives, that they are able to get that information wherever they are. So this clause, we've looked at some of the comments that were made about the architecture and about the fraud detection capabilities and predictive analytics some concerns that were raised in the portfolio committee about making sure that it's not hackable and that it's got firewalls, etc. All of the detail that was raised in those comments is very much subject to both the regulations, but to the actual content of the various digital systems that are put in place under the platform. And we have re-looked at this clause 40 to ensure that it provides and enables the fund to do what has been raised as a concern. And we are comfortable that it does not need changes. So clause 41 deals with the payment of the healthcare service providers. And we've sort of mentioned this before in some of the other clauses because they link with one another. And that's why I cautioned that one must be careful about reading a single clause on its own. And this links to the comments we've made about the contracting units for primary healthcare being the point at which we ensure that providers are paid for the care that they provide and the benefits that they are delivering to the users in their space. We just wanted to propose one amendment, and that is in clause 41(3)(a), where it says an accredited primary health service provider must be contracted and remunerated by a contracting unit for primary health care. Given the amendment that we have proposed above, following the various discussions that have taken place, we would like to propose an amendment that says an accredited health service provider or health establishment providing primary healthcare services contracted through a contracting unit for primary healthcare will be reimbursed by the fund using a capitation strategy. That makes it far clearer and removes any potential ambiguity, and also makes it clear that the contracting unit is in the purchasing space, not in the provider space. Other than that, we do not recommend any other amendments. So, Chair, now we move to a different chapter, chapter 9, which deals with complaints and appeals. There were not that many comments about these clauses. There's several clauses here. So we just go through them. We do need a mechanism where the public, the providers, whether they are establishments or representatives of establishments or individual practitioners and anybody else who is getting services through the National Health Insurance Fund's purchasing process must have an opportunity to raise complaints and make appeals if there are anything that is said about them. So in other words, if a provider is denied an accreditation for any reason, there must be an appeal process. If a user is denied a service, they must be able to complain and appeal, etc. So we have taken notes of all the comments that we saw during the community hearings and in the oral presentations, as well as those that were raised in the clause-by-clause discussion of the portfolio committee. There were some issues raised about the investigation unit, and I think we've already alluded to this under units, but we do believe that the fund must be able to investigate itself. There must be external mechanisms of investigation, so that we do not have any difference of opinion with that. But this is about what the fund must do. And the fund, if there's any question raised, it must be investigated. So you need an investigating unit to be able to do it. And this is not about being the player and the referee. It's about being responsive to what is being raised in the complaints. So we feel that those provisions do not need to be changed in any way. There's a clause 43 that deals with lodging of appeals. There actually wasn't much stated here other than stating that it must be fair processes and transparent, which obviously we agree with. Not sure how one would reword that. But we do agree that the lodging of appeals, anybody must be able to lodge an appeal as I've outlined. So we don't recommend, or we have no changes to recommend on clause 43. Clause 44, there are some changes that we would like to recommend, and they relate back to the previous comments about the power of the minister and the singleness of one minister making so many decisions. So in the current wording, the bill says an appeal tribunal is hereby established and consists of 5 persons appointed by the minister. And we think that the same route should be followed as before with the board members and the other committees, where we would add in subclause 1 after consultation with cabinet. Now, what happens often with these tribunals is that those 5 members are appointed for a period, perhaps 3 years, maybe more, and so the cabinet would be consulted on the ministers signing off of that tribunal, which will meet from time to time when complaints are raised and referred to the appeal tribunal. The powers of the appeal tribunal were not contested or even really raised. They are fairly standard, and they apply in other appeal tribunals, such as we have in the Council for Medical Schemes. So we've got no changes to propose there. In terms of the Secretariat, there's a little bit of a wording here, I think, slipped in during drafting rather than anything dramatic. The onus must be on the Chief Executive to provide a secretariat to the appeal. In other words, you don't want them to have a permanent secretariat of their own. The fund must provide that. So at the moment, it says the Chief Executive of the board. And what we mean is the Chief Executive of the fund. So we recommend that that word be changed. And then later in that clause, it says the fund must keep the minutes and all records of the decisions of the board. But obviously, this is referring to decisions of the appeal tribunal. So that's it's an error in drafting rather than anything dramatic, but we have picked it up and it was brought to our attention. So we would like to propose that that be amended in clause 46. In clause 47, which deals with procedure and remuneration, the same comments that I made earlier about remuneration apply here, and that is that remuneration of these people who sit in these various bodies is already governed elsewhere, and we do not need to make any new arrangements. It's the Minister of Finance throughout the public service and all laws that have been now harmonized, and we comply with that in all of our health entities anyway. So we are not particularly concerned about that. Our discussions with the legal people in the department are that, yes, there does need to be a law that the procedures must deal with lawful action, reasonableness, and procedural fairness, but it's not necessary to state that in any amendment to this clause. So on that advice, we decided that there's no need to amend anything. So now we come to the hard part, which is the financial matters. And in the sources of funding, that's really just allowing the fund or enabling the fund to receive monies. We are in agreement with those that said, you know, raising fines and imposing other sanctions that might have financial benefits doesn't really add value as a source of funding, so that could be deleted. So we do propose that clause 48B can be removed as one of the sources of funding. It doesn't materially affect the sources of fund. What's more important is when we move to clause 49, which deals with the chief source of income. Where's the money going to come from to pay for the national health insurance? So let me first of all deal with the bill. There were some notes above of where the money is at the moment, and we are on record as having said at the moment we spend 8.5% of our GDP on health in the country. And the question is how you direct and spend that for 8.5% of the GDP that matters. And that's where this clause 49 comes in. So clause 49 seeks to take the current money of the public sector, which is largely in the health departments of the national and provincial department, mostly in the provincial departments, and using the provisions of section 32, subsection 2, which we discussed earlier, systematically move part of that provincial equitable share that is for personal health services out of the provincial equitable share into the national sphere, the national domain, under the appropriation for the national department. And then that allocation, the minister must transfer to the National Health Insurance Fund to pay for the services and benefits purchased by the fund. So that's what it says here. The money referred to in subsection 1 must be appropriated from money allocated in accordance with social solidarity. And in particular, The bill specifies the tax revenue, including the shifting of the funds from the provincial equitable share and the reallocation of the funds for the medical scheme's tax credits. This is existing money, existing tax, currently in the 49% of health expenditure that is expended in the public sector. And the only thing we would like to propose as added to this is in clause 2A1, that we add shifting funds from national government department and agencies. And the reason for doing that is because there are some funds, it's not dramatic, but there are funds that are directly appropriated into correctional services for the servicing of the inmates in correctional facilities. And there are some funds that are appropriated to agencies such as the Council for Medical Schemes, which might change, and even other health entities which might change and be redirected. So it's not specifying it, which ones they are, but we just think that there might need to be a provision to amend that. So the remaining question is about generating payroll tax and surcharges on personal tax. Now, the department has always been clear that this is the mandate of the Minister of Finance, and in fact, it says through a money bill by the Minister of Finance to create these any additional taxes. But it's been our view, and it remains our view, that you need to create these as options and potential, even though when the time comes, and this is a rollout over a period, we've repeatedly stated that the transitional provisions, and in the transitional provisions, it says that it will be rolled out over time. Should it be necessary to use a tax that's different from the general taxes, and should it be, in other words, VAT or personal taxes as they stand at the moment, then the option would be open to the Minister of Finance to introduce such a tax because it's provided for in this clause. So that's what we envisage. We envisage that the current budget of 265 billion, which is in the public domain, is that's in the financial year 21-22, which I'm just using as the static snapshot. The bulk of that money would be redirected into the fund. There will obviously be some that remains in national, provincial, and local departments, local government departments for their specified functions. But the bulk of it would move. And the question is how one then redirects over time the 274 billion, which is sitting in the current expenditure of the private sector, 277 billion in the 21-22 year. And that's made up of voluntary payments to medical schemes, out-of-pocket payments, and medical insurance of various forms, plus some contributions from employers. And there needs to be a process where over time, those sources of funding are redirected once they are not needed to pay for private medical scheme contributions once the benefits are paid for by the fund. So it's the same money. It's the question about how the money is channeled over time. But I'm sure there will be questions and we can return to that. Clause 50, Chair, deals with auditing. There were no comments about this at all. Everyone accepts the Auditor General is responsible, and it's very clear what the Auditor General does, and their roles and functions are clear. Likewise, with annual reports, there were some comments raised, but they were really just comments. Annual reports are already specified in the Public Finance Management Act, and the way in which audited statements as well as the performance is reported is required in both the PFMA and the Treasury regulations for all entities. And this one will be no different, so no changes required here. In terms of clause 52, which deals with assignments of duties and delegations of powers, we didn't actually see any substantive comments, and this is a normal procedure that's in all entities where the minister may assign powers and delegate anything that is specified for the minister, and allows the CEO of the fund to assign duties to people so that you don't have one person having to do everything within the organization. It's normal to do that. There wasn't any concern raised, so we're not recommending changes. The protection of confidential information was raised in a number of different forums, but confidential information is very well regulated in South Africa. And instead of specifying all the different laws, because they may be changed over time, we are happy that this clause, which has a catch-all for other legislation prohibiting the disclosure of personal and sensitive information, whether it's the PAIA Act of what you must do, or whether it's the POPIA Act of what you mustn't do, and how and when you make this information available, is very well regulated in the country, and we don't need to do anything more than this. So no changes proposed. Regarding offences and penalties, there were some discussions and there were questions raised about declaring rand amounts in the law. It is the standard process in which laws are published, and we do have this precedent in our other pieces of legislation for entities. So it's not different, but we do think that there was a comment made specifically in the Portfolio Committee under E about selling and disclosing information. And the point was made that some information should be in the public domain and must be transparent. So it's about confidential information that we are trying to protect. So instead of opening an ambiguity, Chair, we are recommending to the Portfolio Committee to include the word confidential information in 55(1)(e). Clause 55 deals with regulations. And it's an extensive list of regulations that may be made. So the normal process with entities is that the entities request the minister to publish regulations, because the way in which the law is structured, only ministers have the power to make regulations, not the boards of entities themselves. We've already been through part of this above about the functions of the board. So what happens is the entity itself would formulate a regulation once it's ready, perhaps to introduce a new benefit or to change the nature of a benefit or introduce more medication into the formulary or whatever it is. And then those go to the minister for the regulation to be published. This list is very comprehensive. We don't envisage that we need more. We've thought about it very carefully, and we think this covers what we need to cover. But at the moment, there's a subclause 4 that requires all regulations to be tabled in the National Assembly and the National Council of Provinces. That's not the common practice. They're normally published in the Gazette for everybody to comment, and the normal period is 3 months. Often its comment periods are extended beyond the 3 months, and so tabling them in the National Assembly and National Council of Provinces may just slow down the process of introducing new benefits or changing the way in which something operational happens. So we would like to propose that clause 55(4) be deleted in the bill. We're almost at the end, Chair. Clause 56 deals with directives. Now, there were some parties in hearings and in the Portfolio Committee that raised a question about what is a directive and why should the fund issue directives. I'm not sure that we were able to cover these in previous comments. What happens is that, for instance, the Council for Medical Scheme will issue a circular. It's not a regulation, and it's not an amendment to the law, but it is an instruction or a guidance on how to implement a change or a particular interpretation of a regulation. And without this tool, the fund will find it difficult to communicate with the providers and maybe even with users of the service, but particularly with providers and with the suppliers who are engaging with the Office of Products Procurement, or as we want to call it, the Products Procurement Unit. So hopefully that clarifies the reason why the department has put this in the bill and supports it, and we would not like to see any changes to this clause. Clause 57 on transitional arrangements has been raised repeatedly in every single forum, and there are some extremely valuable comments that we've looked at and that guide us on this. The concern with transitional arrangements is, in these transitional arrangements, is the period and the specifications of times, particularly because the bill was held up and the implementation of where we want to go has been delayed, largely because of COVID. So the timeframes are already passed or are no longer appropriate. So the first recommendations we would like to make is just to change the dates from 2022 to 23 for phase 1, and from 22 and 26 to 23 and 27 for phase 2. And that's the work that we are just finishing off the preparatory work in this period at the moment. And this would allow us to ratify, and once the bill is enacted, it would make the work that is being done in preparation valid. And then we would be able to accelerate into 22 to 27 period of much of what we've been explaining during this presentation. In particular, the transitional provisions provide for health technology assessment, which is critical to getting the benefits right. Now, that is something that we already have in the medicine sphere within the department, but we haven't had in the past for devices and diagnostics. So it is something that needs to be accelerated during this period of 2023 to 27 to make our benefits much tighter. But it is provided for in the transitional provisions, so we don't see need to amend this any further. There are many things one could put in the transitional provisions, but having gone through each of them, we are not convinced that they need to be there or that we need to amend what we've got at the moment. We think this is sufficient guidance. And because a lot of the transition happens within the Department of Health, within the public service, there are plenty of provisions for us to do the necessary things in the transitional space. So, Chair, that's our comments on transitional provisions. The repeal of amendments or laws we have already dealt with in a separate presentation, and you've given us opportunity to make comments on those. So we're not going to comment on them further. And we would like to just bring to all of our attention section 59. The last section covers us a lot when it speaks about different dates affixed for the coming into effect of different provisions of this act. And that ties into what we stated in the transitional provisions and what I've said in particular about accreditation of facilities. We do need to recognize this is a journey, not an event. It is a long reform. It is very complicated. We acknowledge that, but we think that, and that I'll end with this, Chair, by saying we think that with these few proposed amendments, the bill is sound to do what we want to do to achieve reforms in the health sector. Thank you, Chair.
Thank you very much. Dr. Jacob's network cut off, so he asked me to be in charge. Unfortunately, the first hand was mine. I will noting after me, Honorable Clerk will follow. Raise your hands, those that wants to comment, please, so that I can note all of you. Honorable members, I request that you please note your hand, and maybe the Secretary, Majalamba, will help me to indicate those that are noted that I don't see. The first one will be me. The second one will be Honorable Clerk, Anna Gela, Honorable Philips van Staden, Honorable Ishmael, Honorable Kaba. I don't see any other hand. I'm sure as soon as they raise, I will note them. The first question that I wanted to deal with is the one related to the following issue. I think it's issues that relates to some to maintain the medical scheme should continue as they are in the new NHI environment. We think it is wise to take into account the South African context, because we come from the history of the massive inequality which deprived the poor, not only the poor, but of a good quality of services. We understand that the rationale of the department to allow the medical scheme to offer complementary services rather than to really duplicate cover based on the concern which the existing two-tier system, healthcare systems. We think the government should intervene decisively so that we integrate, we would deal with the fragmentation in funding mechanism that adversely impact the performance of the current healthcare system, which is not continued under the NHI. We also have scarce resources in South Africa in the form of doctors, nurses, equipment, finances, and facilities. We cannot have a situation where the rich cream of the resources serve the few of the population. I'm sorry that I'm being disrupted by people that are phoning because I'm using the phone. We cannot allow the resources that are used to serve the few. That cannot happen. Almost 8.5 billion rands on the healthcare is spent on the country. Half of this 20% of the population. The government is contributing substantially to medical aid in the private sector, which is not fair because the public is paying their taxes to support only the few who are employed by the state. Medical scheme should provide services that are not covered by the NHI fund. There is a fear that the medical aid will be scrapped when NHI is implemented. That is not true. And the aim of the NHI bill is to allocate a different role of providing services that are not covered by the NHI. Do you have a thought on the perspective that you are taking in this regard? There's also an issue which indicates that there will be a relationship between the NHI fund and Office of Health Standard Compliance, and how different, if not all, fund treat facilities that are not met the standard of the OHS for health establishment.
Sorry, Acting Chair, we are losing you completely. Chair, we are losing you completely.
Maybe
you're not audible.
Can you hear me now?
That's better.
Or if it is better, then I'll proceed. Also, the issue of the health benefits coverage in a number of institutions and the stakeholders have made a presentation to the committee in initiating that the bill must indicate that the full list of the healthcare benefits that the population will be entitled to under the NHI. What is the department's view on revising clause 7 of the bill to include a detailed list of the healthcare services that will be covered under the fund? I'm going now to allow Honorable Clerk, and in that sequence. Honorable Clerk.
Thank you, Chairperson. Just want to get my notes. Yeah, I mean, this is an interesting document, you know, from the offset. I want to highlight that the DA unequivocally supports universal healthcare, but the stance is quality. The stance should be quality universal healthcare, not in the current status quo of South Africa. We are treated in our patients are treated in appalling conditions in state facilities and systems that has already surpassed life, and I mean, healthcare at this moment, the system is already surpassed life support, and that the crux of the matter, we will never achieve the outcomes in terms of NHI in the current environment at this stage, and the current status quo of our systems will never be we will never realize our outcomes in the environment we're currently functioning. I must say, Chair, after all the work we have given in terms of input, this bill, our input there's been very little of our input taken. And I feel extremely deflated this morning that after consideration of all efforts from the DA, we surely have not been heard. The documents and changes are extremely disjointed. Much like the Zondo Commission, which finds that Parliament was failing in its oversight duty, and in this case, Parliament is failing in its duty to produce proper public participation. We have followed the department. We have allowed the department to produce a document that ignores the entire inputs of stakeholders and political parties, except for the ANC, where it responds to peripheral issues more than primary issues raised. It also fails to properly address both the legal and substantive issues, and this has that many stakeholders have provided and have not given the opportunity to actually have their views incorporated into this document. And, you know, this really calls for legal recourse. There is an attempt by the NDOH to compensate for the weakness by doing the work of Parliament. The responses don't come anywhere close to deal with the substantive issues that were raised in the hearings. Clause 9 preserves the patronage model of accountability. The report is totally unacceptable, and Clause 33 remains unconstitutional and won't survive a court challenge. Because of the glaring deficiencies of this document, I recommend that they probably comprehend and deal with all issues raised. Financial model and feasibility studies yet to be determined, and yet yesterday the Finance Minister, in his response to a written question to Parliament with regard to the surrenders bill, given the current financial fiscal constraints, he said that your financial model is vague and provides no clarity at the current ratio at the moment in South Africa. And if we look at, given that our country has a 4.7 trillion rand debt in this country, given that tax revenue is already under pressure in South Africa and cannot afford to feed families, drive cars, lost their jobs, and the situation is dire. The debt will increase in the next 5 years to 5 trillion rand by 2024. And then a substantial increase to 5.5 trillion debt ratio. We have no space for more tax or VAT, and there's simply no extra revenue lying around in our country. He was also clear in his response, saying that the cost model will not automatically translate into budget allocations, as they would have to be made part of the budget process, which will take into account the macroeconomic environment and fiscal space we currently find ourselves in. This was answered in a PQ received yesterday, that currently there are 3.2 billion accruals outstanding, which have not been paid. What impact will this have in terms of the financial well-being of the state healthcare and ensuring our suppliers deliver in terms of medical treatment? The billions of outstanding medico-legal claims also has a severe impact on the functionality of the healthcare space. Over 1,010 service providers have not been paid in 30 days. And we also see that over 3,400 ambulances is the current shortage within the country, we do not comply near to the norms and standards, this destroys NHI's provision of transferring patients to other service providers. I must say, Chair, none of our input has been taken into account, and this committee and the ANC expect us to rubber stamp this bill, even when we have raised very critical issues. And it's taken us an enormous amount of time to work through these issues and contribute positively to this committee. And I just feel extremely disappointed that all our hard work has actually gone in vain. We still have not raised the critical issue of the powers of the minister and the accountability role that Parliament will play in terms of transparency. The fact that we need a capable state and management structure within the sectors is not, and also not influenced through cadre deployment and millionaire managers that exist in the system, that just becomes a box-ticking exercise. Or these managers are absolutely just like a post box that they receive and then send out. So being paid exorbitant salaries for doing that kind of work. If we look at the appointment of the SABC board and the communications committee as an example, the committee decided on the possible candidates. The committee decided on were involved with all the interviews, and SAA did background checks on all 32 shortlisted candidates. After the SAA finished the background checks, the committee went ahead and chose their 12 final candidates. The list of 12 candidates will come before the NA for confirmation. So Chairperson, this transparent processes are in place, and we as the Health Committee should also be embarking on these transparent processes. I mean, no real plans to mitigate fraud and corruption, and the NHI will not become another SOE that has huge impact on lives and healthcare of our people. That hospitals are upgraded in terms of the infrastructure that can provide the kind of healthcare Africans deserved, and this has been touted time and time again. We recommended that a holistic strategy be developed between the private and public system to improve healthcare within our country, as we desperately need each other with medical professionals that can guide government with the best models possible that needs to be implemented. And as we all said previously, the public, that we have a duty to our citizens of South Africa to provide proper universal health care. Let's be brutally honest. This has not happened due to a failing ANC government, cadre deployment, and fraud and corruption. We as public reps need to act in a transparent manner and protect the Constitution of South Africa and ensure the outcomes result from the services we provide when we implement policy. And bad policy could always be a really bad effect on service delivery and the lives of our people. At this stage, we still have not received a document with the input of the hundreds of thousands of participants with the public input for this bill. We have also not had any outcome in terms of all the submissions made that were over 300,000 in terms of the amended regulations relating notifiable conditions. Surely this also has an impact on this bill. What has happened to that process? At the last meeting, I think a member van Staden also mentioned this. Then the Ombudsman and the OHSC have a critical role to play in terms of certification and compliance. They categorically told us that they will not be able to perform these responsibilities in terms of ensuring that our hospitals comply to norms and standards because of them being extremely short-staffed. I mean, surely this needs to be dealt with because NHI cannot be implemented if they do not comply these specifications. Many changes have not been made in terms of legislation that needs to comply to support the NH bill. Surely some of these changes that we have now been presented with should also go to public participation before we can do this. I must say, Chair, none of our input has been taken into account, and this committee and the ANC expect us to rubber stamp a bill even when we have raised some very critical issues. In my opinion, this process has been rushed and needs to be reverted back with the necessary consultation that it deserves, taken into account further public participation. We are wanting to ensure that we supply the best healthcare to South Africans. And by rushing issues and by not ensuring that we are dealing with each aspect that needs to be dealt with, I don't think we're going to ever achieve this. So please note that the DA rejects this report with the contempt it deserves. Thank you.
Thank you, Honorable Munyai, for acting in my position while I was struggling with my connection. I am now back, honorable members. I don't know what the order of the names were, which Honorable Munyai had mentioned. I'm going to take the names as I see them on the system, on the virtual system. Okay, but all right. So, Honorable Gela, I will give you system in front of me. Otherwise, I am going to get lost now. So, after you, Honorable Gela, I'm going to follow the system, that which I see in front of me now on the virtual system. After that would be Honorable Van Staden, Tembakwayo, Ismail, Howard, Wilson, Abba. So it's Kela, Van Staden, Tembakwayo.
Excuse me, Chairperson. I'm following Honorable Kaba. I'm not at number 4.
I am purely saying
I'm number 7. I'm number 7, please. Not before. After Honorable Kaba.
Chair.
Thank you.
Honorable members, please look on your system there in front of you on the virtual system. It would indicate how hands were raised in the order they were raised. That's what I see after coming back onto the system. I have nothing else to guide me. I am using what I see in front of me now. If you then have different ideas as according to what Honorable Munyai had raised, then please give me the list now. But I think we're going to spend a lot of time trying to put a list together. At that time, I was not connected. So let us follow what I see in front of me on the system, because the system indicates the order in which the hands were raised. Please, honorable members, you can always come back and add something afterwards.
I'll come at number 7, Chairperson. That's what the Honorable Munyai announced. I'm number 7. Thank you.
Honorable Dr. Tembakwayo, you want to make it difficult. Who is next? Honorable Gela.
Thank you very much, Chairperson. Chair, firstly, let me welcome the presentation that was done by Dr. Nicholas. Chair, as African National Congress, we support the implementation of the NHI 100%. We have had the stakeholders during the engagement that they want NHI as yesterday, and hoping that, Chair, we are going to implement it as soon as possible, because it's what South Africans, they want. Coming to the issues that I want to raise, Chair, Firstly, Dr. Crisp, on the affordability, many stakeholders continue to argue that NHI is unaffordable and should not be implemented before the public health sector is improved enough to provide quality health services. What is the department's position on these two options? That will be my first question, Chair. Secondly, under the definitions, where you have proposed the deletion of uniform in the definition of providers' payments, I need to get some clarity. Does the department propose that the word uniform should be interpreted to mean that all service providers of different specialties should be reimbursed the same way? Or does the word mean uniformity in reimbursement shall apply to similar services being provided to users, regardless who offers such service? Furthermore, Chair, on the schedule on Act to be amended or repealed, the Pharmacy Act contains sections which enable the South African Pharmacy Council to make determinations on fees to be changed by pharmacists. Seeing as this act is not included in the list of acts to be amended, will these provisions continue to exist under NHI, or should the Pharmacy Act also be amended? My other question, Chair, some argue that medical schemes will no longer exist under NHI. Just to reiterate, we do not support eliminating medical scheme. Private medical scheme membership should continue to be voluntary, and whether or not an employer decides to continue to subsidize its employees' contributions to a medical scheme in the presence of NHI will be determined by the employer in consultation with its employees. However, Chair, belonging to the voluntary private medical scheme should not be used as a prerequisite for employment. Chair, those belonging to medical schemes just cannot use it to pay for services under NHI because the fund will not be reimbursed them. The medical aid will play an important role outside of the NHI by providing complementary services. Do you find this understanding to be correct, Chair? My last, Chair, this is what the Minister of Finance in Parliament said, I quote, Finance Minister Godongwane says that the 2023 budget to be tabled in February is unlikely to have substantial focuses on the National Health Insurance, NHI, and will focus on overcoming services delivery backlog in present. Chairperson, as African National Congress, we really support the NHI so that at least it can also assist us and also to make sure that all of us, we get equally service in terms of health. And of course, Chairperson, we do understand that other political parties, they don't want the implementation of NHI, but as African National Congress, we are the leader of the society and we listen to the society when they are saying they want NHI. So Chairperson, in all, I want to say we support the NHI 100%. Thank you very much, Chair. Forward with the NHI, forward.
Thank you,
Forward,
Honorable members. So, since you're now all complaining about your position, let's see how it goes. Honorable Van Staden is next.
Thank you, Honorable Chairperson. Honorable Chairperson, it's been 3 years that we have a committee is busy dealing with this NHI bill. We have our public hearings across South Africa. We've listened to comments of nearly 900 people in that process. We have public written submissions, which was handed in by Parliament from stakeholders and the public. And we know from our reports, there's over 300,000 people who made that submissions. And we had stakeholders and other role players in the medical sector came before our committee as members of this committee and to make their oral submissions, which I think was about 114 people in total, if I read the report correctly. Chairperson, we also as members have made we've taken part in the clause by clause deliberation process in this committee, which started earlier this year and to the point we are now. And it just feels to me that all those massive inputs which was made from the public hearings and the written submissions and our deliberations as well is not adequately responded to in this report, which is in front of us this morning. I know it's a lot of submissions which was made, but I think it would be the correct process to give adequate attention to those massive of hundreds of thousands of submissions which was made at the end of the day. Chairperson, you know our point of view with Freedom Front Plus. We stand by our point of view since the beginning, when this bill was tabled by the previous minister in 2019, but we cannot support the NHI bill. And therefore, Chairperson, please note that the Freedom Front Plus rejects this report, which was tabled this morning. Thank you very much.
Thank you, Honorable Ismail.
Good morning, Chair. Good morning, colleagues. Chair, I must, agree with Honorable Clark. The fact is, it is important that, we receive a response on each and every comment or input that was actually submitted on the NHI. That is why we have a process of public hearings and submissions and discussions. This is actually a massive bill with huge consequences, both financially and a major impact on healthcare services to the country. It's so disappointing that all inputs have not actually been heard or responded to. I mean, if you're looking at the first point, facilities accreditation, we've just had a mild input on this thing, a minor input on this thing. We actually don't have sufficient, input on exactly where the country is going to be standing once the NHI actually starts and how is this going to be actually facilitated. There are no constructive replies to issues raised. Secondly, how many public facilities will be ready with the NHI accreditation and by which date? Thirdly, with regard to a financial feasibility study, Honorable Clark had just stated, and I'm going to be re-emphasizing, the Minister of Finance has stated clearly the cost model will not automatically translate into budget allocations. And this frankly tells us very, very straightforwardly that, the NHI has actually not been funded appropriately. There was no financial feasibility studies. We cannot initiate a plan in this country for such an important aspect as healthcare. It's a constitutional right in our constitution to each and every person in the country. And you can't just, by the way, say that we're going to be adjusting this and we're going to be doing that when there is no constructive plan of action that needs to take place before this NHI is actually passed or funded. This tells you that, we're going nowhere with the NHI in this country when it comes to reliable information. Now, with regard to service providers paid on time, Currently, 3.2 billion rand in accruals outstanding as a result of service providers not being paid on time. That is at least 1,710 service providers which have not been paid by the Department of Health. Now, under the NHI, this will be even worse. We stress over and over and over again, fix up the things that are going wrong in the system before jumping and going to the NHI. Now, considering that we have major shortages of EMS services in the country, and under the NHI, the NHI requires a transfer of patients from one service provider to another. Obviously, with the shortages, this will negatively impact the provision of health services to the country. And we are receiving no input on this matter at all. I think this was actually highlighted at so many of our NHI public hearings, to stating that we don't have efficient EMS services. Most submissions, physical submissions, were stated that fix up the system, things are going wrong. We haven't actually received the amount of submissions that actually agree to the bill and how many did not agree to the bill. We've already had whistleblowers highlighting suspicious payments to the value of 850 million rand. Corruption Watch highlighted 670 whistleblowers reports that were filed just regarding corruption in the healthcare sector alone. This NHI, we're looking at billions and billions of taxpayers' monies. Where are we going to as a country? Chief Justice Zondo report stated clearly that Parliament did not do as much oversight as it should have. And this will be even worse under the NHI if Parliament is not afforded to elect the boards and not the Cabinet. I mean, over and over again, we've seen recommendations that Cabinet should do that. Parliament has a job to do. And when things go wrong, and same as what Chief Justice on the report stated, Parliament did not do as much oversight. We want to do the oversight. We want to allow Parliament to do the oversight. So we're stating again that Parliament should be the actual oversight entity and not Cabinet. As stated before, we do not have a capable state. We have a high unemployment rate and cannot put an extra burden on taxpayers to finance the NHI fund that has not been properly thought out with no financial feasibility study. Effectively, the fact that all submissions have not been answered and responded to is a type of disrespect to all those that actually took the time and effort to provide submissions to the NHI. We need to ensure as a health portfolio committee that we do justice to this. And by rushing it is not going to get the country anywhere. We rather fix up the current healthcare system first. We all agree, especially the Democratic Alliance, we stand for universal healthcare. And as my colleague stated, quality universal healthcare. So fix up the system first before we jump from the frying pan into the fire and make things even worse when it comes to healthcare to the country. Thank you.
Well, next is Honorable Howard.
Okay, thank you, Honorable Chair. I also welcome the presentation that is fully presented, fully support the implementation of NHI bill. Here, I just have 3 questions just put here. Firstly, for application of the Act, in clause 3.5 of the bill, it is indicated any transactions concluded the fund in terms of the provision of the NHI bill must be exempt from Competition Act 1998, Act number 89 of 1998. Why does the department deem it necessary for this exemption? And how does it contribute to achieve the objective of universal health coverage? Number 2, can I please get a comment from the department? Would it not be enhancing under the definition of health products if the word safety is included together with quality and efficiency? Lastly, Chair, is amendment in the transitional arrangements suggesting that 1 additional year will also be added in phase 2, or the exact duration for phase 2 will be taken at a later stage? And will the body responsible for HTA be granted recommendatory or decision-making powers? Thank you, Chair.
Thank you, Honorable Kaba.
Thank you, Chair. Chair, I think let me start first by welcoming the report and indicate that what Honorable Mnyai and Honorable Geller indeed are asking indeed questions of clarity, and that registers progress. Indeed, we really are for NHI and we need the NHI. But Chair, maybe also to have my submission, especially on medical schemes. A number of stakeholders, mainly from the medical scheme industry, have argued that it is better for medical schemes to be allowed to play a duplicative rather than complementary role under NHI. They have raised a number of objections to clause 33, saying it is unconstitutional, and it is not reflective of what has happened in other contexts. Can the department explain the rationale behind the need for medical aid schemes to play a role as envisaged under clause 33? As a first question, Chair. Furthermore, Chair, also would like to raise the following, that some of the comments from stakeholders relates to the exclusion of the Competition Act from transactions concluded in terms of NHI bill. They argue that there is a need for clarity on how this will impact on industry and how it will work in practice. One will expect that the health professionals and physical facilities will continue to be regulated under the NHI. It might well be that some providers are large enough to benefit from economics of scale and also from their larger, well-established supply chain. However, reimbursement levels for services should remain the same and determined centrally. We expect that to be an NHI provider, some minimum set standards must be met, which make it once again critical for various service providers to compete on efficiency and maintenance of quality standards. With such conditions, it's highly unlikely to see anti-competitive behavior. We would agree with our understanding on this matter. I think the department may also clarify on that, Chair. Lastly, Chair, my submission will be, or one before the last. On clause 6A, does National Quality Improvement Plan, Chair, that you have made reference to in your comments include both public and private facilities? If it's only in reference to the public health establishment, what efforts are being implemented to ensure that quality deficiencies in the private sector are addressed? Chair, I know that the department has stated that the international tourists and those with work visa will be provided through a special dispensation. How will the fund deal with South African citizens who work abroad and therefore already have insurance at their workplace elsewhere outside South Africa? Will there be a different payment mechanism for these individuals? Just checking, Chair. Maybe we would get responses, Chair. On reimbursement, Chair, why is it important for NHI fund to implement a restructured investment strategy as part of the reforms to move towards achieving universal health coverage? Some, Chair, have commented that they consider single payer system inappropriate for NHI system in South Africa. Reviewing the NHI white paper, which has been consulted widely, the aim is to create a single payer and a single purchaser. We understand that the NHI will manage the mechanism for pooling finances for the health system and strategically purchasing health services to maximize income and risk. To maximize income and risk, Chair, we understand that the fund will create a single pool of funds that will be used to purchase services that benefit the whole population. Acting as a single payer and a single purchaser, it will be able to reap the efficiency benefits of single purchasing power and economies of scale, and ensure that the incentive structures for healthcare providers are integrated and coherent. My question, Chair, will be, has the NHI bill remained true to this policy or not? I think the department will help us there on the response, Chair. But Chair, just to clarify on the recent comments here, the 2023 budget will not include NHI because the bill still has to go to the NCOP. The budget request should be for 2024. So let's get that understanding very clear. Chair, as I rise to support what Honorable Gela, Honorable Harvard, and Honorable Mnyai in welcoming the presentation, and we are for the NHI. Thank you, Chair.
Thank you, Honorable Dr. Chembukwayo.
Thank you, Chairperson. The NHI bill, as presented, I mean the responses from the National Department of Health, is still not viable and cannot be accepted in its entirety because of the following reasons. Since very important suggested amendments have still not yet been taken into consideration. Those amendments coming from either the oral and or written submissions, including very important suggested amendments from us, from some of us, some of the political parties that have had so many arguments and questions stated. But whatever we have argued about, whatever we have presented, whatever we have tried how hard, hasn't been included. And secondly, that the department is neglecting the general infrastructure problems that has been experienced throughout the country, and that there is not even a single move to date to attempt moving into the direction of infrastructure improvement. Throughout the presentations, there has been comments like, we are not going to make any changes, or we must not make any changes with a given reason that the National Department of Health have looked into international arrangements. We forget that we are dealing with South Africa, which is a unique country of its own kind. Does it mean that what the South African public comments and their suggested possible amendments made, like I said, either orally or written, are not taken into consideration? We are not guided here by the international agreements, but we can always acknowledge some of those things. But it cannot be the only reason that guides the NDOH to neglect or to set aside some of the important amendments that needs to be included in the NHI bill. And to further ask to say what guided the department on choosing this selected, considered, according to them, that are considered the relevant information that are included and that are considered the possible and the best amendment in the bill. What guided them to make this choice? And secondly, what makes them to neglect our own contributions? Why is there only a one-sided type of the choice of the information that needs to be reflected in the NHI bill? I mean, there is a lot of no change needed. It's a simple statement in a clause under comments to say no change is needed. Does it mean that the information argued at that point as amendment is just set aside? This is very much unacceptable. And lastly, to say the role of Parliament and Portfolio Committee should be considered. The reason given that we have the role of oversight is not strong and is also not accepted. And from the economic freedom fighters' point of view, we reject this report. It's not yet clear. Like I suggested before previously to say, we need to make a pause of this thing and go back and address issues that needs to be addressed. And then we can always come back and look into the NHI bill. So we reject it. Thank you.
You, Honorable Wilson.
Thank you, Chairperson, and a few comments from my side, although I am principally covered by colleagues before me. Page 2 of your presentation talks about making progress to achieve universal health coverage. However, there is substantial evidence to support that SA already achieves universal health coverage, and I have raised this before. And these are supported by the Health Market Inquiry, a WHO report, and the International Labour Organization World Social Protection Report of 2017. The problem with the statement in this policy is that it is incorrect. And no matter how we ask for it, how many times we ask for it, there is still no evidence to the contrary that has been provided. The discussion to promote substantial, equitable, appropriate and effective public funding for the purchasing of healthcare services. There's been absolutely no technical costing analysis performed on the NHI, despite pleas, despite long discussions, despite requests for it. The only official report attempting to cost the national health system was done by the Ministerial Task Team on Social Health Insurance in 2005. I mean, this is absolutely ridiculous. It's just, there's been absolutely no inclination or indication of how this can be done and whether it is feasible. You talk about acting as a single payer, single purchaser, and in doing so, the NHI will reap the efficiency benefits of monopoly purchasing power and economies of scale, and ensure that incentive structures for healthcare providers will be integrated and coherent. Well, where is the feasibility analysis supporting this claim? Currently, the state acquires medicines and materials via tenders from private suppliers. In the tender process, suppliers provide their lowest prices and sometimes even at below cost, with the knowledge that they can recoup lost margins by selling at higher prices, according to the SCP for medicines, in the private sector. If the state becomes a monopoly purchaser, there will not be a private health sector against which suppliers can recoup their lost margins of much lower prices to the state. Prices to the state or NHI will then increase and not decrease as claimed. This is Economy 101. Alternatively, if the NHI dictates lower prices, then suppliers will go out of business or exit the market altogether, just simply worsening access to care, and we're all in a bad position. This is also why we are opposed to taking out the Competitions Commission completely. It's just not appropriate and is unjustified and unfair. Let's talk about the Minister of Finance in his response to our questions, and I think everybody will have a copy of that. At the end of the day, it's the Minister of Finance who announces additions to tax or VAT or how incomes to support the national budget are going to be made. And I mean, he was very, very clear in his response to our questions that some sort of financial feasibility model would be required and must take into account the state of the fiscus and the micro and macroeconomic implications as we stand as a country now. And the situation is not going to improve anytime further. The cost of living is going to shoot through the roof. Unemployment is going to stay at a ridiculously high level. And with all of these things taken into account, we cannot pass this bill without a feasibility study, without a financial model. It's and without the input from the minister, this cannot even be considered. You can't pass a bill without this. You pass the bill, and then the Minister of Finance says it cannot be done, or we cannot fit this into the national budget. Then what? Then what? Where does this bill stand? You cannot pass a bill unless you know that it is feasible. And right now, we don't have a financial feasibility model. There are considerable changes proposed in this presentation. It has got to then go back to the public and stakeholder participation. And it can and it must be done. We have seen this in recent bills. If you want to stay above board, then all possible reasonable processes must be done. And that is exactly what we will have to do. This must go back for public commentary. You talk about the 8.8% of GDP spending is way above what other countries of similar economic development spend on healthcare. Well, I ask, please, that you provide the evidence of this. The average total health spend of 51 upper middle countries that we've investigated is 7.2% of GDP. The average health spend of the same 51 countries is 4.1%. Same as South Africa. So you are misstating and misleading here. We have not dealt with the medical legal claims of 125 billion. How is NHI going to pay for this? Who is going to pay for this? Because NHI actually can't pay for it. You cannot tax people and then use the money that you have raised from them to pay for mistakes and a crash of the healthcare that you created. You can't do that. You don't have the right to. You can't take taxpayer people for problems they did not create. NHI is going to be a problem. Medical legal claims are going to be a problem. Lack of funding is going to be a problem. No financial model is going to be a problem. This must be rejected. Thank you, Chair.
Thank you, Honorable Siwela. Next.
Thank you, Chairperson, and pardon me if I will repeat some of the questions that others have made. I've been in and out due to network connectivity.
Honorable Siwela. Honorable Siwela.
Connection. Chair, let me now Congress support this report from the understand that public. Can you hear me?
I can hear you now.
Okay. Yes, Chair. I just said that welcome the report from the department, but also to indicate that public participation has already taken place, so there would be no need for us to go back there. Secondly, Chair, just on the role of the Minister of Health, stakeholders have indicated numerous interrelated concerns regarding what they deem the excessive role of the Minister of Health with regards to the various functions of the NHI Fund, including processes such as the appointment of the board and a number of committees. Can the department explain further the role that is proposed for the minister with regard to the fund and how they see these roles as not interfering in ensuring transparency, accountability, and robust governance of the fund? Secondly, Chair, based on the recommended amendment to clause 3.5 on the relationship between the NHI Fund and the Competition Act, will the fund accept if contracted and accredited service providers engaged in private business with service providers located outside South Africa over and above the work they will perform and get remunerated for by the fund. Furthermore, Chair, on the contracting units to primary health care, the contracting units for primary health care units are proposed to be local level structures responsible for service planning on behalf of the NHI Fund. However, many comments that were submitted to the committee indicated that these units are a duplication of the District Health Management Office. Can the department explain the difference between the roles and functions of the two structures? Lastly, Chair, when will the department effect the necessary amendments required in other acts in order to make way for the introduction of the NHI? The African National Congress supports the NHI bill. I submit, Chair. Thank you.
Thank you, Honorable Lengwa.
Thank you, Chairperson. Let me welcome the report from the department with some disappointment. We as IFP are very much disappointed because there are submissions which we submit as an IFP as our contribution to this NHI, but we didn't hear it. That's why I'm saying that we are disappointed as an IFP. As an IFP, we are fully support the universal health care. Now, what is the use of medical aids? Because no clear function and payment for that. We as IFP are worried about shortage of medication, appliances, shortage of infrastructure. Infrastructures are dilapidated, and shortage of nurses and doctors in all our healthcare services, and it is not catered in this NHI bill. How are we going to get medication because no clear budget about it? We need a clear interpretation from the department because no budget put in place, and how and who is going to look after this budget almost daily. Thank you, Chairperson.
Thank you. Honorable Clark, you said you missed only one question only. And then Honorable Kaba, one question only.
Thank you, Chairperson. I was covered by my colleagues, so I don't need to repeat it. Thank you.
Okay, Honorable Kaba.
Chair, thanks, man. Chair, I just want to say the Minister of Finance is part of the cabinet that submitted the NHI bill to Parliament. We must not misunderstand him. He's simply saying he cannot include it in the next year budget because financial models are based on assumptions. It is actually not true that the NHI bill has not been adequately consulted, as Freedom Front had observed. NHI policy and bill were consulted for more than 10 years. And there are some of wanting to prolong their benefits at the expense of the public that pays their medical aid. Lastly, Chair, Ms. Wilson, when does the public participation then stop? It was done very extensively, and here are the numbers to support this as a fact, not anecdote. 11,564 attended, provincial and public hearings. Out of these 11,564, a total of 961 made oral presentation. Of the 961, a total of 820 in support and the NHI and a meekly 118 opposed. Only 23 of the 961 raised issue unrelated to the bill. These are facts which are even contained in the report of this committee, our committee, even your committee. In fact, we don't need the report back today. These numbers were there and we observed and noted each and every comment and reaction. As the ANC, we heard the nation cry and we must respond accordingly, Chair. Lastly, Chair, as you were saying, I must only raise one question as my last submission. It's just around the question, Chair, to say that, Chair, on clause 4.3 on population registration, will individuals and children who enter as tourists in South Africa be afforded the same services in an event they fall ill whilst still within the borders of South Africa? I submit, Chair. Thank you.
Thank you, Honorable Gela.
Thank you very much, Chair. Chairperson, it's a legacy hand, my apology. But I fully support Honorable Xaba on his submission. Let us not mislead the society, Honorable Wilson. You were part of the NHI public participation throughout the country. You heard when the people, they said they want NHI. So let us not be negative towards the people once. Let's implement the need of the people as we are representative of the people of South Africa. Let's implement NHI. Thank you very much, Chair.
Thank you very much, honorable members. I must make a decision here now. We at 1 o'clock, which is the time we had allocated for this work today. I must still give my inputs, and we must still receive the response of the National Department of Health to what has been raised by the members now. So it's something I'm giving consideration to at the moment. But let me raise what I wanted to raise, and I'll make a decision after this. So, honorable members, you've raised quite a number of points today. Many of these are repeats of what had been raised before, and I understand when it's raised, but we must also remember that the department has had to consider all of the inputs and then come with their recommendations and their suggestions and their inputs on what had been proposed during the public hearings and through the written and oral submissions, and then have to make suggestions and or amendments, because that is the whole intention of what we're doing. It is to give the department an opportunity to come and respond to what has been raised. And I think with that in mind, it would stand to reason that not all of us would necessarily agree with what the department brings this morning. But that is exactly the point about a multi-party organization like Parliament, that everyone is able to bring their views and that those views are considered and are listened to. So, honorable members, I think I need to maybe consult also with Ms. Majalamba for a short moment, very short moment. If you could just all bear with me for about 2 minutes, I'll be back with you now. Thank you. Honorable members, I am back, and we had applied for this meeting to range from 9:30 to 1300 hours. At the same time, we had thought it important to apply for a meeting for Friday morning, where we were going to adopt the report on the oversight visit to Eastern Cape, and also to consider and adopt some minutes. So I am going to give my input, Honorable Clerk, before I will take your hand. I still have to give my input. I'm only giving you an understanding of where my thinking is at this moment. And then after I had given my understanding, I will take your hand and we will make a decision about the way forward. So my input on what has been raised, by the department is around a concern that has been raised around the Competition Act clause, which stated that the NHI should not be exempted from the Competition Commission. So the ANC agrees with the exemption of the Competition Commission because the NHI is a public policy intervention in a health system financing that does not seek to support both public and private providers to make a profit, but to support universal health care, which is largely about public purpose. We've been hearing some members say that the private providers would be making money, and it's just a system to provide income or greater income for the private providers. So we need to reiterate that this is a public policy intervention in itself, and that it is going to support both the public and the private health sectors. And our understanding is that the Competition Act seeks to address uncompetitive behaviors, particularly amongst providers of various services that seek to maximize profit. Therefore, the NHI seeks to establish a one-buyer fund that will purchase healthcare services from multiple providers that will compete based on quality and not on price. And then thirdly, the market cannot be a free-for-all, and all those providers who meet specific standards will be allowed to operate. And what NHI is proposing is a single fund, but multiple providers. And I'd like to know if the department agrees with this. Then secondly, I want to speak about the funding for healthcare services offered in central hospitals and whether this will be any different from other accredited health hospitals at different levels of care that will be contracted to the fund. The second last point I want to raise on this particular issue is that there have been arguments that the proposed system in the NHI bill will not increase access to healthcare on a progressive basis, and that it would rather deprive many of access that they currently enjoy. There are also arguments that the NHI bill currently contradicts a number of universal healthcare principles as outlined in the 2017 white paper. While the NHI bill successfully addresses fragmentation in financing, it risks further fragmentation across a number of other health system dimensions was also raised. Now, our understanding is that the NHI reduces fragmentation of funding pools. It reduces fragmentation of service provision between the public and private sector service. It will also end fee-for-service, which creates fragmentation in the system. And if our understanding is correct, we'd like the department to answer, and please also elaborate on the question that I had raised. And the structures of committees, we've heard around those structures and committees. There have been a number of submissions made about these as stakeholders have indicated concerns regarding the costs which would emanate from the various technical committees, which will be established as part of the establishment and functioning of the fund. What is the department's opinion on this, and how do they propose that costs associated with such structures are controlled by the fund? Then, just to mention that the ANC had listened to stakeholders. So in our engagement, we had proposed as the ANC during the clause-by-clause deliberations and all deliberations, we had made an effort to amend our suggestions, and we had actually proposed certain amendments. Additionally, we've seen the National Department of Health also proposing certain amendments here today. So my question is really, why do the other political parties not also then consider to bring amendments as we have done, instead of just saying that they reject the report? Some say they reject the bill, yet they still respond to what is raised during these deliberations, etc. And I'd really like to see that we all work together towards raising our views on these issues, but also being willing to bring amendments where we deem it necessary to bring such amendments. With that having been said, honorable members, I just need to give Honorable Clark, who has raised something about Friday's availability. And I will also have to see, there was also another message from me. Honorable Clark.
Thank you, Chairperson. Friday is a very difficult day for us because we have a Federal Council meeting on Friday morning. So, and Member Wilson is also part of Federal Council, so we won't be able to attend a Friday morning meeting this week. Thank you.
Thank you. So, honorable members, Friday mornings are normally for committee meetings, but I'm not going to fight with you if you had set up another meeting. I think what we would then do is we will complete the work today. We'd have to go up to probably 1340 or 1345, get the department to respond, and we finish the work then today in light of what Honorable Clark had just raised. Dr. Cripps, can you please respond? Let me call the DG first. DG, and then for you to respond, and then add to whomever you want to. Thank you.
No, thank you very much, Honorable Chair, and thanks to all the members for the inputs and the questions. To manage time, we can see that we have a bit of a problem. So I'd request that Dr. Cripps just hits the ground and responds to most of the questions. He may invite me or Dr. Tulare later, but I think he must take the bulk of the questions. Thank you very much.
Thank you very much, DG. Thank you, Honourable Chair. Thank you, honourable members. And we take note of all the comments and the criticisms. But we want to start off by saying we have considered everything that we've heard since the beginning of the process, but considering it and taking it into consideration does not necessarily mean agreeing with it and incorporating it. We have heard very diverse opinions, very diverse comments. We're dealing with, on the one extreme, where people wanted complete obliteration and removal of the private sector. And on the other side, we are looking at comments who want an entrenchment of the current private structures. In the middle, we as practitioners within the department and specialists in our fields are trying to attain something that is achieving better equity and is putting the mechanisms in place to do that. We know it will be difficult. So when comments are made that we should be consulting with medical practitioners and so forth, we do. And many of us are medical practitioners and specialists and registered specialists in our own field. And we interact with colleagues in all of those environments. But we don't always agree, and we do differ about some things, and that's the nature of our professions and of a democracy. So with those as just overall introductions, and we obviously can't respond line by line to every single comment that has been made. And of the 300,000 emails that were received, most of them were just said, I agree or I disagree. They didn't elaborate on what they agree or disagree with. And in forums that we engage with now, even with practitioners, when we ask them how many have read the bill, if it's 1%, we are happy. People are commenting without even having any knowledge of what is in the bill. So it is very difficult under those circumstances to know how to engage. But let's comment on respond to a number of the comments as quickly as possible. So the first questions were asked about our understanding and our views from the department regarding complementary schemes from the Honourable Munyai. So I think I'm broadly in agreement, and the department has had this discussion, that complementary medical schemes are there and are there to stay and are written into the bill for a very deliberate reason. We do not see that there will ever be a termination and a rejection of all medical schemes and all private financing mechanisms, because no state is ever able to provide all healthcare to everybody. There are always exclusions that medical science makes possible, but they are not necessarily in the interest of the broader public or possible within the framework and the budgets that are available at the time. So it doesn't matter what country you look at other than the one or two extremes, everybody makes provisions for some kind of other financing and other provision of healthcare. The point that needs to be made, and which we hoped we had made, is that it must not duplicate what is provided by the fund. And there's a fundamental difference that we will not agree with. And as technical specialists in our field, whether a party believes or doesn't believe that that is the way to go, that is our view, and that is what we have put from the department. So we are comfortable that what we are trying to achieve with complementary schemes is to complement what the fund should be doing and paying for everybody in the country, except for those conditions outside. Our relationship with the Office of Health Standards Compliance, I actually thought I had covered that in the presentation, but I will just strengthen it. We have a very high regard and respect for regulators and entities outside of the department. There are presently 5. We work very closely with all of those 5 entities. We do not interfere with what they do, but they have to implement the policy of the government, like we do in the department. and they have to implement it with their technical independence. And so that's the same with the Office of Health Standards Compliance. The department meets with the Office of Health Standards Compliance now. We set it up. It used to be inside the National Department of Health. And we work and refer cases to the Ombud, and we are working to separate the Ombud from the Office of Health Standards Compliance deliberately to try and get that autonomy and independence, because we are health professionals and we respect that the need for that patient confidentiality and the working towards quality. So the questions that were raised is that we look forward to working with them. We have meetings even now and making sure that we are moving in the same direction. We will do everything we can from the department to strengthen their roles so that they are able to support us. And we agree that they need to be funded better in order to gear up. But it's a relatively fledgling organization, and Rome wasn't built in a day, so they will gear up until they have greater capabilities. There was also a comment about us wanting to declare the full benefits in the law. No, that would definitely not be wise to do that. 2 years ago, 3 years ago, we'd never even heard of COVID. When I was a practitioner and I graduated, there was no such thing as HIV. We didn't have some of the diseases we have today. We certainly didn't have the interventions. There were no replacements for ankles when some of us graduated. Now you have replacements for just about everything. Hardly anything was done through scopes in the days when some of us graduated. Now everything is done through scopes. Medical science and medical technology evolves all the time. And so what one is able to include in the benefit is very much, it changes over time, and one does not want to try and ring fence things, even in the generic sense, because you want to be able to adapt and include benefits as science changes. So we would not like to see a deliberate listing of inclusions or exclusions of benefits, because you'd have to go back to the Parliament every year to amend those benefits. And that's why it should be in regulations. And that's why you want these technical bodies in the advisory committees to be assessing and being critical about what should and should not be included. So from the department, we've been at pains to explain that universal health care and universal health coverage are not the same thing. And in fact, we were inviting all the members of the portfolio committee to the national event that's being held in South Africa on the 12th of December. It's a whole day event hosted by the World Health Organization. It's Universal Health Coverage Day. Please, by all means, join us, send friends, send colleagues to join us. We will make it public of how you can link to this event so that everybody can understand what is universal health coverage and what we are doing versus what other countries are doing about universal health coverage. We have heard many testimonies, specifically in the portfolio committee, about people who have been reduced to financial hardship or not been able to get health care because of the systems we have today. But universal health coverage says universal. We all get what we need, when we need, where we need it, without financial hardship. So it doesn't matter how we argue it, we do not have universal health coverage in South Africa. People do have access to healthcare, provided they can afford the transport, afford to pay, afford to suffer, afford to wait, etc., etc. So that is what we talk about when we talk about universal health coverage. But we can debate it after the 12th of December at length, because it's a specific definition that we are working towards. So also criticism that we have not consulted and we've ignored other parties. So to the honorable members of the portfolio committee, we will be happy to go back and show you the exact clauses that the department incorporated from specific recommendations in the portfolio committee meetings over the past months. We can show you exactly who said what, because we kept records of the names and there are records of these meetings. So we feel that honorable members have done extremely well to bring things to our attention that we hadn't thought of and we have incorporated in the bill. So I'm sorry if the honorable members feel we have ignored them. We don't feel we have ignored either the comments that were made in the public space or by the honorable members. We would be happy to show you which clauses and who raised them. So the question of the financial feasibility model and so forth, this is going to go round and round in circles forever. And we've all heard quotes of what the Honorable Minister of Finance said this week and has said before. I hope nobody is under the impression that the Health Department does not sit almost daily with the Ministry of, well, not with the Ministry, but with the Treasury and discuss these matters. We have constant meetings about the current budget, about the NHI, about issues that concern them, that concern us, and what's in, what's out, and how we should go about making different changes and so forth. But the fact of the matter is, we have an extremely inequitable funding of our health services. I've mentioned it before, I'll mention it again. We have spent 8.5%. I never said 8.8, by the way. It's 8.5% was the figure quoted. It changes from year to year depending on what's in and what's out and what is being spent. But at the moment, it's 8.5% of GDP was spent according to the figures given to us last week by National Treasury. And that is made up of 49% spent in the public sector and 51% spent in the private sector. And we are happy to share the exact breakdown with the exact figures that were given to us by National Treasury. Now, in the government space, that is, at the moment, this year, 15% of government spending is allocated to healthcare in the public sector. And that includes the spending in the Department of Defense, Correctional Services, and in the national and provincial health departments. And it includes capital and recurrent expenditure. The private sector spending is largely medical scheme funded through voluntary contributions to medical schemes, which makes up 83% of that portion of what we spend as a country, and 14% is out of pocket. And that's the portion of the population who is either paying for their healthcare when they run out of their medical benefits, or people who are not medically insured who want urgent healthcare and they go and they buy, sometimes at great hardships to themselves. So what does it look like? What do those figures look like at per capita expenditure? At the moment, that the portion of the budget that is spent, the 49% that's in the public sector, is 5,500 Rand per capita that is being spent in the public sector. And the private sector is 25,500. Now, there may be margins in this, and we've worked into the different margins in our models, but don't for a moment think that we're not looking and interrogating all of these figures. The challenge is, how do we spend 26,000 Rand on one section of the population and 5,000 on the other, and not harmonize this in some way that everybody gets a better access to all of these resources? And are we really giving better healthcare because we give more healthcare in the private sector and we pay more for it? The department doesn't think so. We study and interrogate these things. On average, we're spending over 9,100 Rand per capita. But the average is a lie because it is so diverse. And even within these figures in public and private, what we are delivering to people is very diverse. The question is, and the advice we've got in talking to the WHO and economists, one of whom will be talking on the 12th of December at the WHO's Universal Health Coverage Day, is you're going down a rabbit hole if you try and cost something that's going to take you 25 years to stabilize and get equity. Even if you're trying to do it in 10 or 15 years, as some countries have done, it is not advisable to go that route. You work within the envelope you've got and you push your changes to the extent that that envelope allows. So I hope honorable members are not under the illusion the department has no insights, has no model, has not been involved in any of these discussions. We do, and we continue to struggle with them. And we are very grateful for the debates that we have with Treasury and other colleagues. Very happy to go into details of those if time allows or at a different occasion. Regarding the powers of the minister, so we have, as we indicated in the presentation, really looked at this because it was raised so often. And we've debated it with colleagues, with our legal colleagues, with everybody that we can think of. And we have taken into consideration various lobby groups and the political parties' comments about this. We are still convinced that Parliament should not be appointing boards. Parliament should be holding, observing, managing, overseeing those boards, but not appointing the boards. And that's our opinion. So we have taken into consideration that the comments that a minister alone is a potential trouble, because you don't always have a minister that's appointed to the post who acts in a specific way. But we think by introducing a broader responsibility to cabinet, who's much more visible to the public, that it does bring in that checks and balances. But we acknowledge that not everybody's going to agree with that. There's an interesting comment made about how we need to bring together the holistic public-private approach. We think that that's exactly what this bill does. We think that's what some of the political parties are objecting to because we are still having a private sector. What we are trying to do is finance it differently, but nowhere in the bill does it say there won't be private providers. In fact, it's very clear there must be private providers, and we must accredit and include those private providers because it's an enormous resource that is currently not harnessed for the majority. And we think that this is the way in which the bill has been written, and specifically with the amendments that we are proposing, this will be even strengthened. So there were also comments about, so we don't think that none of the comments that some people have alluded to, have said, none of the comments have been incorporated. They definitely have. And we are happy to document who raised which comments which we have included. There were comments about, sorry, I've got many notes here and some of it's not really legible. I was writing so fast. So about the affordability and arguing that we must fix the public service first. I think we as a department have been in the public space frequently saying it's not either or. You have to fix the public service at the same time as creating the new framework, because if we don't address the systemic challenges, then the only way to deal with a bigger public sector is to invest more in the public sector while you've still got the private sector. If we spent the 26,000 Rand per capita that we spend in the private sector in the public sector, it translates to 1.6 trillion Rand that we would need to spend the same amount on everybody in the country. So it's clearly not viable to go that route. And this is not the way in which one does these costings. You have to be far more discriminate. Where's the waste? Where's the duplication? Where's the theft and fraud? And how do you get rid of it so that you release more money, both in the public and the private sector, for patient care? We spend a lot of time on that kind of discussion in the department when we look at these clauses of the bill. So we are convinced that we don't need to fix the public service first. We need to fix it, period. And we need to fix management and the DG, and there's a team working in the department with the provinces, fixing a whole range of issues around management of facilities, improvement of facilities, being very strict about the medicine shortages and so forth. But Rome was not built in a day, and it's taking a long time to get on top of past problems. Yes, the Honorable Geller raised the question of should we not include the Pharmacy Act? Yes, we should include the Pharmacy Act, and there are clauses in the Pharmacy Act which do need to be amended. And you're quite right, and I'm sorry I didn't raise it in the presentation, but it's definitely on the radar. It was also raised the question about scrapping medical aids. No, we don't think they should scrap medical aids. We think they need to look different. We don't want medical insurance products because they are difficult to regulate, and they don't respond to what we are trying to respond to with the Medicine Schemes Act. And those exemptions, which are historical and are in place at the moment, we don't think from health they add value, and we think that they just complicate the delivery environment. We also heard the Minister of Finance, and we have apparently interpreted it differently from what some of the comments that have been made today. We make inputs from the National Department through the DG and the Chief Finance Officer to the budget process. So we have submitted our requests from the National Department and on behalf of the provincial departments on what we would like to see incorporated in next year's budget. And we have not included more money for the NHI because there isn't an NHI fund established yet. So the Minister of Finance is absolutely correct. What will be invested in is the capability to do the detailed design, which the honorable members have been asking us to provide. And some of those posts have been advertised, and into next year, we will strengthen that capability. It's only when there's a bill that you will see money beginning to be moved in the requests and in the submissions that we'll bring through the budget process to Parliament. So the Honourable Minister of Finance is absolutely correct. And obviously it's his department and the Treasury who is publishing those figures. So we do not see substantial investments in the NHI, but we do see investments, and they have provided for funds in, well, we have submitted, of course, it's got to go through Parliament still, for money to the health departments, including the National Department, to improve the infrastructure, which some of the honourable members have raised with us, and which the DG, together with the Deputy Director General for Hospital Services and his staff, are working on with the provinces. So that's where you will see the changes, hopefully, when these matters are tabled in the early part of next year. We don't get an objection to the NHI from National Treasury. We have discussions and sometimes disagreements about small elements that we are working together to refine and work on them together. It's not feasible to go into every little detail. So yeah, Honourable van Staden felt that we have not responded clause by clause with all the stakeholders. I hope I've responded to that by saying that we have, in fact, read and categorized and looked at all of these. We've looked at the same matrix that was presented last week to check that we didn't miss anything in our summaries of what we were hearing in the department, and to make sure that everything that was raised there has been considered. We don't agree with everything that is raised by everybody in all of these parties. Otherwise, we wouldn't end up with no bill at all, because there are such divergent opinions. I hope I explained about facilities accreditation, and we can't tell you which facility will be ready by which date. What we can tell you is that every facility is under some form of quality improvement program at the moment in the public sector. And then there are these nodes, as was raised, one of the honourable members asked about the quality improvement program. And yes, it does include private facilities, and there are problems in private facilities. There are some serious problems in private facilities because they don't comply with all aspects of the current National Health Act with regard to storage of information and making and holding of management of patient records and so forth. So there are problems in the system. That doesn't mean that you don't need to move forward. It means you need to fix the things and that are wrong. And you need to, at the moment in our National Quality Improvement Program, we are learning and getting templates so that other hospitals, other facilities can learn from those improvements. It's a relatively small investment of providing leadership and input to make sure that everybody is moving in the same direction for quality improvement. Yes, there are shortages all over. There are personnel shortages, particularly in the public sector. Even the private sector will tell you they've got personnel shortages. There are challenges with EMS. But until we are able to purchase both public and private ambulance services and patient transport services and other emergency services in fixed facilities in an equitable manner, we will continue to have parts of the country and segments of the population who don't get those services. And that's why the bill makes provision for those ambulance services. The reason it's dealt with differently is because in the schedules to the Constitution, ambulance services are not a concurrent function. All other health services are a concurrent function. All other personal health services are a concurrent function. Ambulance services are an exclusive provincial function, and the municipal health services, which is largely environmental services, are an exclusive local government function. So that's why it has to be dealt with in a different way in this bill. We have repeatedly acknowledged that there is corruption and fraud within the system. We know from reports in the private sector that it's over 90 billion rand a year stolen from the medical schemes. We know that in the public sector, there are all kinds of highly embarrassing, very high profile fraud and corruption that are currently before the Special Investigating Unit. But there are mechanisms in place, and I'm sure the honourable members are aware of the proclamation where the President has now authorized the SIU to investigate all health departments. That was at our request from the department, because we know that there are problems and we want to understand where they are to fix them and to deal with them, with people, with the consequences that are necessary. So the National Department of Health tabled this bill, drafted this bill. Yes, there were lots of consultation, and as we heard, it's been more than 10 years that we've been busy with first a green paper and a white paper and another white paper, lots and lots of consultations, presidential compact, etc., etc. It can hardly be said there's been no consultation. There's been wide consultation. There's just vast differences of opinion on how to go about it. And we have to pick a route as the department. We've listened to political parties, we've listened to professional colleagues, universities, looked at different countries, and we are not a slave to a particular country. We have got different elements from different countries that we think will work in our environment. We have the greatest inequity in the world, and we have to deal with it in this bill in a way that will fix our challenges with our problems in South Africa, and it's not going to be easy. There were questions around the Competition Acts raised a couple of times. So I want to emphasize I've sort of lost my notes here. One of the honorable members asked us about, or said that health is a public good. That's how we see it. Public health medicine people see health as a public good, not as a tradable commodity for people to make profits. So that is the point from which we have commented, and we have incorporated or suggested the incorporation of changes. So we have produced a bill, we have listened, we have a suggested incorporation that tries to tighten some of the ambiguity that might exist in the wording, and we have suggested the additions of various sentences and words that we think remove some of the challenges. But competition in the space where we all do not control our own, what happens to us, whether we get run over on the way home or have a heart attack or whatever else, gets sick, it's not all preventable. And when we get sick, we do not need to be at the mercy of an ambulance that can only pick up a private patient or can only go here or can only do that, as we've heard in the various meetings. So that's the view of the department, and we are not ashamed of that view. That's how we feel. So the question about the single payer model. There are many different models, and you get mixed purchaser provider models that are implemented in different countries. We have deliberately gone for the single payer, single purchaser model because of the inequity of this country, where we have this huge dichotomy where 51% of everything we spend is spent on somewhere between 15 and 20% of the population. And the figures that I have explained, and we can go into and give you the details of that from Treasury, from Stats SA, and so on. It's just intolerable. You cannot continue with a situation where there's just a continued increase in the cost of private healthcare to the extent that a lot of people drop off, and the public health system is just stagnant and accumulating more and more people. And by the way, the provision for the next 10, 15 years, our population is aging. Our total growth rate is very small. Our death rate is down. Our under 5 mortality rate is down. The rest of our stats are all leading to a growing bulge in middle age, who are all going to get older. And as health sciences improve, we will be dealing with elderly people. We've just returned from the UK, and that is actually their problem, is their population pyramid has moved up, and they have a huge number of older people with chronic diseases and needing care in care homes, and that's what's consuming their budget. We will head that way because society is improving, even though sometimes we don't think so. So yeah, I've issued the invitation for the 12th of December. We'll make it available to the Secretariat so that everyone's aware of what's happening on that day. I've answered the questions of no technical costing. There's been plenty technical costing. In fact, 10 years ago, I was part of the team who was doing the evaluation for the Actuarial Society on the costing of the NHI, and many of us have been involved in it for many, many years. The question of the tenders and the providers and the costs and so forth, the health department's job is to get healthcare to as many people as possible, as cheaply as possible, so that nobody has financial hardship. So there will always be a tension between how we fight for our tender prices, and we do well most of the time on the 1,200 products that we do manage nationally, to keep those prices as low as possible. What we need to do is get better certainty in the marketplace. And when I talk about the marketplace, I'm talking about supplier marketplace, pharmaceutical companies and so on. There are trade-offs to be made. If we import from the cheapest provider all our medication, we will not grow the South African market. But if we grow the South African market, somebody must pay the price of that additional cost, which sometimes is up to 40%. And those are matters that we discuss with the Department of Science and Innovation, Trade and Industry, and other departments like DIRCO and so on. There are constant and ongoing multi-departmental and interdepartmental committees looking at all of these things. So it's very difficult to say, well, this company is now going to raise their prices and everybody's going to suffer. It doesn't work like that. Yes, the Ministry of Finance will decide on taxes eventually, but they need the tools. They need to have it available to them. At the moment, the Ministry of Finance, the Treasury issues what the taxation is going to be. SARS collects the tax, and we get an allocation. So we get the money that we get. Whether there's a new channel or whether it's through raising VAT or raising personal taxes and no choice to use a payroll tax will be a separate debate. But if you do not create the capability or the possibility of that route to raise a tax, then you've lost an opportunity. And many countries do use payroll taxes to raise their money for their national health insurances. So it's not an unheard of new thing that we are dreaming up from the National Department of Health. So our understanding about consultation is that the amendments that we are proposing from the department, and even if there are other amendments that others have proposed, which the Portfolio Committee agrees to incorporate, are very minor. They're important, but they're minor. There's no ways that this constitutes a complete rewrite or a different approach to the national health insurance. From our perspective, we have stuck true. Single purchaser model, single payer model, purchaser provider split, public and private providers, both all being contracted in as accredited providers, improving the quality of lives for everybody. Nothing in the overall intent of this bill has changed. So we, from the department, would be very surprised if there's necessary to go back for further consultation. But then, that's not, the legal advisors will advise us on that. Honorable Wilson says, I'm misstating the GDPs and the GDPs of other countries. Well, this is my bread and butter, and this is the environment that I live and work in, so I'm very happy to have this debate. We can look at all 200 countries or more that the World Bank and the WHO quote on, and we can look at their percentage GDPs, their percentage government spending, the nature and structure of we can look at it from every way, as is well stated. There are lies, there are damn lies, and there are statistics. I'm still comfortable we're in the right ballpark, that we spend a lot of money as a percentage of our GDP, and we do not get the outcomes that we should get because we spend it badly, because our private sector is incredibly expensive and duplicative, and our public sector is struggling and struggling and struggling, perhaps, we think underfunded, but it's 15% of government spending. I'm almost done, Chair. There were questions about the Competition Act. I think I've already discussed, because we think health is a public good. That's obviously why we put the story of the Competition Act in. We feel quite strongly about that, in fact, very strongly about it, because otherwise we're never going to get on top of the inequities that we have. The roles and functions of the DHMOs and the contracting units for primary health care. Now, this is something new. These are things that we have seen around the world, and we've seen in South Africa that work well and don't work well in different provinces at different stages of the evolution of our health services since 1994. We are still in that learning phase. So right now we have an indirect conditional grant that we are using, where we have set up one contracting unit in each province, where we are now implementing the digital systems, the staffing, the integration of the public and the private sector, getting all of the private people onto the HPRS so that they can start to register patients in that environment, working out the mechanisms of exactly how the payments will work. That is currently, thanks to yourselves for approving this in our last budget, some money that we have available to start doing that. It's early days, and we acknowledge that we don't have all the answers. What we do know is that this country is extremely diverse. So the solution for downtown Joburg will be very different from rural Eastern Cape and very different from the Northern Cape for different geographical and population reasons. And that's what we are busy looking at the moment. There was, Honorable Suela asked about the amendments to the other acts. We have noted the debate that took place about whether they should happen at the same time as the bill. At the time when a clause is activated, that it becomes law in terms of section 59 of the bill. That is the stage at which one decides whether the amendments to the Medical Schemes Act or the Health Act or one of the other 11 acts that are there is appropriate to make those amendments at the same time. But trying to make all the changes either now or after is going to make it extremely difficult because we will have conflicting pieces of legislation. So our view and the advice we have from the legal teams that we interact with is that you do it all at the same time. There may well be other changes that need to happen to acts later. We will discover those in the years to come, I presume. The Honorable Klengwa asked about medical aids. We are not suggesting the abolition of medical aids. We don't think you need 76 medical aids with well over 250 different packages that nobody really understands. I was talking to someone the other day. We were going through a particular package of one medical scheme, 53 pages of fine print. And the person whose medical aid is over 90. And this person's asking you, what does this mean? How do you expect a 90-year-old person to choose a package amongst 76 medical schemes, or even just the open schemes? It's just not, it's not viable. But it doesn't mean we don't need medical schemes. What we do need is medical schemes to cover what the fund does not cover. And that's why Section 33 is written in the way it is, and that's what we believe. That's what we would like to see. The issue of no medication budgets, this is something the department has been dealing with during the course of this year with the provinces. We are encouraging provinces to ring fence their medicine budgets at the moment so that they get a better handle on exactly what those costs are, and that it's easier for them to ensure that they're able to pay within the 30 days that is spoken about. But there are historical accruals which are still being dealt with in many of the provinces. And so it's not ideal at the moment. It's far from ideal. But we are not the only ones who have been running out of medicines. The private sector has been having lots of problems we've been trying to assist them with because of the global supply chains being quite seriously disrupted in the last 2 years. There were questions about caring for tourists and foreigners and South Africans who live abroad. The basic tenet of what is in the current wording, and even with our amendments to the wording, is that if you're a South African, when you're in South Africa, you are entitled to healthcare at the point of care. And that your medical scheme, no matter how you have it or where you have it, when you are in South Africa, you will get that healthcare paid for because you pay your taxes. If you never pay taxes and you're not part, and you're not a citizen and you're a visitor, that's what we were discussing about the health insurance products, because not everybody calls them medical schemes, and obviously international products are not regulated by our medical regulator. So we need a different mechanism to deal with those travel insurance and other insurance policies for visitors. But I'm sure there's going to be a lot of detail, and when we do get our staff appointed, this will be the job, amongst other things, for one of the people who is to be appointed. So Chair, I'm on to the last set of comments or questions about NHI not increasing access. NHI will increase access. And I'll give the example that I like to give, because I drive past Diepsloot regularly when I'm on my travels backwards and forwards in Gauteng, and I still find it really mind-blowing that the community of Diepsloot, just as the index case I'm talking about, has to travel either to Charlotte Metsege Hospital or across the highways into Ekurhuleni and go and get their healthcare somewhere else, because there's no public hospital anywhere near those people. But literally a few kilometers down the road, there is a private hospital. And at one point when I was talking to that private hospital's management, the occupancy was 38%. How can we have 38% occupancy of a private hospital when a community must drive kilometers past in heavy traffic to get to healthcare in a very busy central facility? It doesn't make any sense to me whatsoever. Right now, there's no mechanism for us to purchase healthcare from that private hospital. But with the amendments to the NHI bill, that's exactly what we will do. We will purchase that healthcare, and this is just an index case. There are hundreds of communities where we could say similar things. Chair, two last comments. You asked about the funding of central hospitals. Will it be any different? So central hospitals are where we train specialists. There are currently 10 central hospitals. The department, and yesterday we were hearing a discussion about this, and the DG will be picking it up with the DDG of hospital services. We were looking at the categorization of hospitals. And we need to do that because we are moving into a different set of pressures on us as we move towards NHI, and we can't just be looking at the public sector. But the 10 central hospitals, and there may be more that are designated that in the future, are critical because that's where we train our specialists. We do some undergraduate training there as well, but all specialist training is heavily focused in those facilities. So it may be, and there are provisions in the wording of the bill as it is now, to fund a portion of those budgets directly, so that the additional costs, and that's what we do with the conditional grants at the moment, where the additional costs that are associated with training are paid for, not just on the fee for service. So there are mechanisms, and the bill will allow that to happen when the time comes, but we have to work on that. The last comment, Chair, was a question you asked about structures and committees. So the honourable members are probably not aware of how many structures and committees we already have in the National Department. There are ministerial advisory committees that are brought together and disbanded on a regular basis. During COVID, we had 3 ministerial advisory committees. We have a NAGI committee. It's a National Advisory Group on Immunization. It's a standing advisory committee. Because in the department, we cannot hope to employ that kind of specialist knowledge. So we bring people from universities, from specialist bodies, from private companies, and so on, into these ministerial advisory committees regularly. And we have, in the space that I look after, committees called NEMLAC, where we look at, it's the National Essential Medicines List committees, where there are specialists from all over the country involved in that committee. From time to time, those committees recommend technical working groups to work on one specific solution and then disband. So we have had a technical working group working on the coding systems for the NHI. They were disbanded after the end of their submission. So this does happen. And we are mindful that these things cost. But if you don't have the technical expertise and you don't bring these people together, you make even bigger and more expensive mistakes. Those who are public servants or work within the broader government, in other words, the public entities, not just the public service, do not get paid for their time and their efforts when they contribute. But private people who are outside of the government services do get paid. So I hope that helps to clarify some of the questions, Chair. I'm sure we could engage for a very long time, and we are happy to do so at another time should you wish. Thank you, Chair.
Thank you very much, Dr. Crisp. Honourable members, DG, before I step off from this, is there anything, DG, you'd want to maybe say?
No, thank you very much. I think Dr. Crisp was very comprehensive, Chair, and we don't have any much to add. But as said, we would like to engage with members if they are available on the 12th for the full day arranged by WHO. Thank you very much, Chair.
Thank you very much. Honourable members, thank you very much for your indulgence that we were able to continue and try to complete this section today. I must just recognize that Ms. Isaac of the Legal Service of Parliament had sent an email to apologize, but we didn't see that email, so apology is noted for our meeting of today. Honourable members, also don't forget about your written submissions. We have been asked as political parties to forward your submissions. I think this is going to be the last opportunity or the last time that I'm going to give you any reminder for those who have not yet done so, because our next 2 meetings is going to be quite different. And by then, at the time when the state law advisors and the legal services of Parliament will come and give us their understanding of everything that we've done up to date, and whether that's within the legal frameworks which are required by our constitution, by our legal system, our justice system, etc., whether we actually comply with those. They will give us feedback at the second meeting from today. Honourable members, I'm going to take only this one hand, but I'm not going to open discussions now. So, Honourable Wilson, it is not an opportunity to open discussions. We're at 6 minutes to 2, And Honorable Clerk, I definitely want to close this meeting. And if it is about the meeting on Friday, I am still getting to it. If it is about that meeting, please lower your hand because I am getting to that part. But I'm not going to allow a reopening of discussion. So I'll take Honorable Wilson.
Thank you, Chairperson. No, I'm not going to reopen the discussion. I think we've said what needed to be said. And I hear that you're going to discuss Friday with us. However, you know, principally apart from the sitting on the 6th, the morning of the 6th Parliament now stands. And is it our understanding then that we are actually at the end of this process and will only continue next year? Because obviously we work against the parliamentary program, which is updated on a weekly basis, and we have made other plans accordingly because of the constituency period we go into. Thank you.
Thank you, Honorable Clerk.
Thank you, Chairperson. I'm covered by Member Wilson because, you know, we've all got programs set in our constituencies as well going into that period. Thank you.
Thank you. So, honorable members, I've reminded you of the written submissions. Then on Friday, we've applied for a committee meeting because we have a report to adopt. And I wouldn't want that report to stand over to next year. And that is the oversight visit to the Eastern Cape. And then secondly, we would still have to consider and adopt some minutes, which we had planned to do between 9:30 and 12 o'clock on Friday morning. And that would be our last meeting for this year. We would then, the next meeting that we have would be the legal services groups coming to give us their input, as I had alluded to earlier. So, Honorable Clerk, is that your previous hand that's still raised? Thank you. So, honorable members, Friday mornings are still dedicated to committees. And whether you had made arrangements for another meeting is now not something that I should really be consider and be concerned with. I hope that one of you at least can attend on Friday morning this particular meeting, because we had applied for this meeting, it had been approved, it is outstanding work. We'd like to end this year on a good note, not having outstanding reports when we start next year, and we will resume with this work next year when Parliament starts again. So, honorable members, thank you very much for your attention, for your time, for your dedication to participate. This meeting is then closed. You will receive further communication. Thank you.
Thank you, Chair.
Thank you, Chair.
Recording stopped.